There are a lot of negative reactions, as you might expect, to the SCOTUS's decision when it comes to student debt. We have some pretty strong dissents, including from Elena Kagan, who says she was scathing about the majority's invocation of the, quote, major questions doctrine, which we've seen come up quite a few times in the last few years, and you'll probably see a lot more coming up, which the court's conservatives have developed as a basis to give judges the power to strike down regulations and other actions if they say Congress was not explicit enough in authorizing them. She described the doctrine as made up, and the reason she did that is because they just made it up recently. It's not even like, hey, it was a made up thing back in the 1880s that they're resurfacing. No, they just made it up recently because it's convenient for them. It's specially crafted to kill significant regulatory action by requiring Congress to delegate not just clearly, but also micro-specifically. There, she's referring not just to this, but also when this was used previously to limit the EPA's ability to regulate certain types of emissions. This is a standard that has never before been applied by the Supreme Court, but is now being applied by the Supreme Court specifically to stop the government from doing anything that might mildly inconvenience the rich and well-connected. Justice Kagan's dissent also accused the majority of exceeding judicial propriety by taking the case at all, rather than ruling that Missouri had no standing to sue because it did not suffer any revenue loss, however much it opposed the student loan relief program. Quote, no proper party is before the court. A court acting like a court would have said as much and stopped. That's what a court acting like a court would have done, but a court acting like the court of last resort for the wealthiest people in America probably would act exactly like this.
Right, in all seriousness, this is the thing that is really the death knell of all these weird ass suits that people try to use to get to the Supreme Court to overturn things, is standing. You're not suffering, Missouri. Who's suffering? How is anyone suffering? That argument is an argument against any kind of tax.
Or any kind of debt relief.
Any kind of debt relief, any kind of anything that the government would think to do. There is no one getting hurt by it. That's an argument against investment in the military if you don't directly benefit from it.
Yeah,
like, and there's so many things about the military that you would that you don't directly benefit from, that they invest money in. That money comes from you theoretically, and that's not even really how all these grants actually work. It comes from a bank,
sure.
But the other thing that this is an argument again, that insane, like, important questions, major questions doctrine is poorly. It's like, even if you're making up a fake name for a fake doctrine, don't call it the major questions doctrine. Use some Latin or something to kick up more of a smokescreen. And you know what? Exactly. You know what fails the major questions doctrine? The Bill of Rights. The Bill of Rights doesn't take into consideration how, first of all, the Second Amendment is so dumbly worded that it wouldn't pass the important questions doctrine. None of that would. There's so many major questions that are not answered by that, and we answer them every day. It's insane that the Supreme Court would weigh into that, and you can tell that in the way that the justification for their most recent decisions either says, yes, I believe in laws passed by legislatures, or no, that's not it, I'm gonna weigh it in, even though the legislature was like, no, we went through the actual process you're supposed to go through.
Yeah, well, look, there were multiple. They were only really ruling on one of the two sort of paths to challenging this. Both were BS. The state one of, we're gonna lose out on revenue, doesn't literally make any. You could use that to invalidate virtually anything the government does. The PPP loans, like, I know I think people have invoked that, but I think they've invoked it in the wrong way. Many of the businesses in these places, had they not gotten the loans, might have had to take out loans at the state level and paid interest and fees on it. Because the PPP program existed at all, they didn't do that. So the state, in the case of state loan programs, or private businesses at the state level, lost out on potential revenue. There, you can't do PPP. It's ridiculous, it doesn't make any sense. And then the individual thing of, I don't have student loan debt, so I'm being harmed because I'm not being benefited, is again, that's a justification for virtually no program to exist, because there is no program that benefits everyone equally in the exact same way. Everyone can claim damages as a result of that. It makes no ideological sense. They know that, but they also know that there's nothing we can do about it. They have 6 spots. They're gonna have six spots for a long time. That's just the way that it is.
Check out the Damage Report podcast each day, wherever you get your podcasts, whether Pocket Casts or Stitcher or iTunes. You can join me as I give you the news and stories you want, with a range of co-hosts and interview guests jumping in on the fun each day. Again, that's the Damage Report, wherever you get your podcasts. And if you get them at iTunes, don't forget to rate and review. Sometimes I'll read them live on the show.